Hey everyone, welcome to another live recording of Trump's Trials and Tribulations, New York Trial Dispatch Edition. Today is May 10th, 2024, and I'm Roger Parloff, a senior editor at Lawfare. I'm here with courts correspondent and legal fellow Anna Bauer, editor-in-chief Benjamin Wittes, and special guest Jacob Shamsian, legal correspondent at Business Insider. Let's start with a bit of news, even though it's a little out of order. At the end of the day today, we got some news about scheduling. Anna, can you tell us about that?
Yeah, so as we were wrapping up today, the judge, Justice Merchan, asked the prosecution where we're at with scheduling. Recall just a few weeks, or excuse me, just a few days ago, we heard from the prosecution that they would need maybe about 2 more weeks. That was on Tuesday, I believe. And then today we heard from the prosecution that they feel that by the end of next week, it's possible that they could rest their case. They also indicated that they have 2 more witnesses left. We know that Michael Cohen is almost certainly expected to be one of those witnesses. And so it leaves open the question of who the other witness is. I know that I have thoughts about that. Ben has thoughts. Jacob, I'm curious if you have thoughts about who that witness could be. But that is the news that we got about scheduling. Of course, keep in mind I believe it's next week that Barron Trump's high school graduation is set to take place. Justice Merchan has granted Trump permission to go to that high school graduation, and so therefore court is not scheduled to be in session on May 17th. That's next Friday. So if the prosecution is correct, then they could rest their case by Thursday of next week. Just a few days of court. That's Monday, Tuesday, and Thursday that we would be in court. And then, of course, the defense has their case that they're able to put on. However, my understanding, and again, curious for thoughts from Ben and Jacob, my understanding is that the defense doesn't seem to have too many witnesses that they plan to put on. So we could have jury instructions and a verdict very soon, or much sooner than I think many people expected.
Well, why don't we just go ahead and start guessing who that second witness is? Jacob,
I'm speculation from the three of us. Special guest first, of course.
Cool. Yeah. Well, before this podcast started recording, we were discussing possibilities. I had thought about Keith Schiller, which is the person Ben raised. He is Trump's longtime bodyguard who came with him into the White House for a brief period of time at the beginning of his administration. And he's sort of like the missing, in terms of like the chain of custody for the checks, so to speak. He's the one guy who, handled them between coming from the Trump org and FedEx to the White House, to the White House employees before they got to Trump. So that could make sense. I'm inclined to think he won't come though, because, he does seem like a Trump loyalist type of person. And we've already seen all the paperwork knowing he handled this. And we saw a lot of testimony that he was like outside the suites when Trump had sex with Stormy Daniels, and I can imagine like that just getting very messy at this stage of the trial, and causing issues that perhaps the prosecutors want to go there. At the same time, maybe he could be a defense witness, and so maybe the prosecution will want to front that. I'm kind of unsettled on where that question lands.
So who's your prediction? If not Keith Schiller.
I am actually, as a reporter, I don't make predictions. I just write what happens.
Okay, we make predictions.
Okay, I think Keith Schiller is possible, but I agree with Jacob. I think he's too much of a Trump loyalist. I think that maybe some of his testimony might be cumulative as well. Then again, it seems like maybe he does have some specific knowledge about receiving these checks. At one point, they were being sent to his address. He's also Trump's longtime bodyguard. He has been mentioned again and again within testimony. For example, it was elicited that I believe it was Hope Hicks heard Stormy Daniels' name for the first time when she was on a plane, and Keith Schiller was, with some people on that plane as well, talking about a golf tournament that occurred in which Stormy Daniels was there. That, of course, may very well be the golf tournament in which Stormy Daniels alleges that she had a sexual encounter with Trump and that Keith Schiller was standing outside the door. We've also heard over and over again that the person who is the best person to reach to get in touch with Trump during some of the time period that this was going on was Keith Schiller, that he facilitated all these phone calls for Trump. So it makes sense that as a fact witness, they could potentially call Keith Schiller. However, with that said, we have heard very little about the campaign finance aspect of this case. It is a part of the step up charge or the object crime, in that there has to be, the prosecution has to prove that there was an intent to promote or prevent the candidacy of a person through unlawful means. And so that unlawful means, there could be a number of things. It could be a tax crime. It could be a campaign finance crime. The prosecution has indicated that indeed it is related to campaign finance laws. And so it's possible that we could get somebody who is maybe connecting all of this who is an expert witness, for example. There was on the list of potential names that could come up during the trial, someone who was listed who is a campaign finance expert. That person is someone who potentially is a counter to the expert witness on campaign finance that the defense potentially wants to bring whenever they put on their case. So it could just be that connecting all of the dots of this requires having someone come in and explain campaign finance to the jurors, because we really haven't gotten a lot of that. We also heard today that the prosecution intends to admit a video of Trump on Larry, or wanted to, it was ultimately denied, but they wanted to introduce a video, correct, right? It was denied, yes. Wanted to introduce a video of Trump in 1999 on, Larry King Live, I believe it was, talking about campaign finance. So it just may be that in terms of sequencing, we're looking at some campaign finance testimony as opposed to more of a Keith Schiller figure.
Okay. Ben, what's the correct answer?
So I am perplexed by this situation, honestly, because I do think they have name-checked Keith Schiller so many times that in contexts where you don't need him to come and betray Trump, you merely need him to come and verify facts that are already in evidence, much the way Rona Graff did, and Hope Hicks did, and Madeline Westerhout did, right? These are people who were loyalists, but there are certain ministerial facts that are important to the case that you can kind of get them to admit to while being loyalists. And my assumption had been that Keith Schiller they were referencing him and very specific facts involving him, both at the stage of the initial encounter between Trump and Stormy Daniels, in which he is a pivotal figure, perhaps the pivotal figure other than the two of them, and in the carrying of the checks. And so it does seem weird to me not to close the loop and have him show up and verify that. On the other hand, Anna's point is absolutely right. They have to show intent to violate laws, and they've presented no expert witnesses regarding the law. And so are they planning to do that in closing argument? Are they planning to, somehow they've got to get evidence that this was with intent to violate one or more of these other three statutes? And it does seem like some kind of an expert witness is the only really appropriate way to do that. And so I would say I was surprised to learn there are only two witnesses left, given that Michael Cohen is one of them, which means there's only one witness left. And I am a little bit perplexed, and I guess I I would think that unless there is some other way to do it, like, for example, getting Michael Cohen to testify that he was doing this intending to violate the law, intending to violate tax law, right? Unless you really think you're going to turn Michael Cohen into your expert witness, in which case you could bring Keith Schiller. I do think the establishing that element of the offense is probably the more important thing than hearing from the bodyguard.
And I assume we've had nothing at all about the tax object crime. No expert talking about
No, except
what.
None at all, except that I think that one's an easier one, because if you say, I, Michael Cohen, and remember they already have the controller saying this, we set this up to double it to disguise for tax purposes the plus up, right? I think that one is actually an easier one. It just doesn't get you to election interference.
Yeah. It's just unusual because you're increasing your revenue you're overstating your revenue instead of understating it, which is the norm in tax reform.
Did you know, Michael Cohen, when you made this arrangement that you just testified that Donald Trump instructed you to make, did you know that you had an obligation to the IRS and to New York's tax authorities to state your income accurately?
Yeah.
Did you know that reimbursements are not income? Did you know, right? Like, I think that one you can get around. I think the campaign finance one is much harder to get around without some accounting to the jury of what the actual substance of the law is.
Unless he's allowed to say, I pled guilty to it and did time for it. I don't know if he's gonna say that.
Definitely get that in.
Yeah.
So to be clear, though, that I don't think that because I think that there were in the pre-trial motions, it's maybe not coming in as substantive evidence of Trump's guilt, like the guilty plea itself.
Right.
Yeah.
So we had a series of short witnesses today. Jacob, can you summarize what they were about and what the prosecution was doing with them?
Yeah, so we started off with the remaining part of Madeleine Westerhout's testimony. She talks more about working for Trump. In general, it wasn't like super bombshelly. There was this one strange moment where during cross-examination, I think it was, Trump's lawyer tried to ask her about documents, and she said like the first time she saw it was that morning when her lawyer showed it to her, and the judge quickly shut that down, and that was very strange, and I don't know where that was going to go. But otherwise, it wasn't super interesting. I do think that one thing that was interesting about it, which I actually have a piece coming out this weekend about it, is there's this defense that's emerging through the cross-examination questions that Trump was just like a multitasker, that he was really busy, that he was like, signing executive orders, he was signing proclamations, that he was like, what's a check to Michael Cohen? Sure, just scribble with a Sharpie and, move on. And, therefore there's no intent, or he didn't really know anything about this, or, this is Michael Cohen's whole thing. And she did make I think she made a point to say that he was constantly like signing things like proclamations and executive orders, and had meetings sometimes when he was doing them. So I think we're gonna see a lot of that in closing. I think that's maybe a little bit of a preview of what we can expect. Otherwise, we had custodial witnesses. There was a witness, there was one guy who worked at AT&T and one for Verizon, and they testified about getting these text messages and call records over, and there were two employees of the DA's office, one who had been seen before, Georgina Longstreet, Georgia Longstreet, and this other guy whose name I can't remember, but I found
Jaden something Schneider.
David Jarmel Schneider.
Jaden Jarmel Schneider.
Oh, I thought it was Dave. Oh, I heard
David. He was a recent Columbia graduate. I googled him. He wrote this paper about Alvin Bragg's enforcement of marijuana laws, actually. And I guess he got hired. He's a guy. Sparring.
I want to say, like, nobody has held up better than he did under Emile Beauvais' cross-examination. This is an impressive kid, and he's doing research for the DA, as was I said Georgia Longstreet the other day was super impressive. but she didn't have a fierce cross, and he kind of did. I mean, Beauvais was polite to him, but was really trying to grill in on stuff, and he just stood his ground and corrected Beauvais on some stuff. It was pretty impressive display. Again, I said it about Georgia Longstreet. We'll say it about Jaden, whatever Schneider. If you want to come work for Lawfare, there's a place for you. Get in touch. But wait till after the trial's over.
He double majored in like philosophy and math, I think, which is a very impressive combo.
He's a sharp kid,
and he was very endearing too.
Yeah.
Like he managed to kind of go toe to toe with Beauvais, and he also, I will say, like me, struggles with how to pronounce Emile Beauvais' name. Beauvais.
I think it's Beauvais.
I think it's Beauvais. Yes, but he was very endearing.
So I mean, so what he was testifying about, which elicited this fierce cross, so to speak, is he was basically bringing out these phone records with Michael Cohen and Joseph phone recording records, and kind of pointing out when he was talking to Alan Weiselberg and when he was sort of in the thick of these negotiations for the hush money and getting reimbursed for them. And it seems like Emile Beauvais was trying to say that there was some discrepancy there, especially between like the recordings of calls and the calls themselves. And he's like pretty inflammable. He's basically saying like, yeah, the procedure is like, like we're showing you the relevant ones, but we pulled all of them, and you actually have those, as part of what we turned over in evidence. And just because this recording ends here doesn't mean like the call ends there. You know what I mean? So I think he really understood what was happening and answered it in a really smart way.
So at the end of the day, we had a pretty significant legal argument. Anna, can you take us through that one?
Oh, the Weiselberg dispute.
Yeah.
Yes. So one of the key questions here, it's been known throughout the trial that the prosecution does not expect, or it was not expected, that Alan Weiselberg would be called. Alan Weiselberg, of course, was the CFO of the Trump Organization. He himself has recently been in legal trouble, including trouble for perjury related matters.
Which he is in jail.
For which he is, that's what I was about to say. For which he is now at Rikers in prison, and so there's been this question of why is the prosecution not calling Alan Weiselberg? Particularly given that it seems like there's maybe 3 people in the world who know what Trump knew when with respect to this reimbursement scheme or falsification of business record scheme at the time that it was created, which is the relevant legal question for the prosecution proving the case. And those 3 people are Trump himself, Alan Weiselberg, and Michael Cohen. And so there was this question that we've been talking about at Lawfare of, how does it impact the case if they don't call Alan Weiselberg, they just put Cohen on, and then the jurors are thinking to themselves, well, what about this other guy who clearly has knowledge of what was going on here? So this was raised at the very end of the day after the jurors left. Emile Beauvais stood and said that he wanted to raise this issue because it's, and there's a lot of missing context here, I will say, Roger, because we have not been privy to some of the things that are going on behind the scenes. There's still things that are not quite being docketed, or maybe it's just going on in chambers and between conversations with the parties. But my understanding of it is that the prosecution intended to admit into evidence a separation agreement between the Trump Organization and Alan Weiselberg that basically says that, as a part of the separation agreement, he's going to get a good severance, but he can't go and, talk to federal or state prosecutors voluntarily, or else he risks losing that that severance. And so the prosecution wanted to kind of admit this into evidence as a way of showing the jury, this is one reason why we haven't called Alan Weiselberg, because he's basically, forbidden from talking to us as a part of the severance agreement, and he's maybe kind of in Trump's pocket as a result. So Bovey said, we think this is overly prejudicial. We also have a hearsay objection to it. Alan Weiselberg isn't going to testify, and they're basically using this to impeach someone who's ultimately not going to show up at the end of the day. And then, Ben, I'll hand it over to you to explain what happened next.
Yeah, so what happened next was that Judge Merchan was upset by this, and he accepts that he asks, like, well, there's this obvious solution to this problem, which is a subpoena and compulsory process. And so have either of you actually found out whether this guy will testify? And Bovey, who had just said, this is a problem for both sides, we have things we would want to adduce from him too, immediately reverted to, we have no evidentiary burden here at all, and no, we're not going to call the guy who can implicate our client. And the prosecution turned around and said, look, the problem for us is that he's promised in this document not to talk to us, so we can force him to talk to us by issuing the subpoena. But then the first time we would ever find out what he's going to testify to is when he's in front of a jury, right? And that's an impossible position for us to be in. So no, we don't intend to call him. And Merchan said, I'm sorry, I don't accept that. That you have the central witness you want to admit this deal, this contract, by way of explaining why he's not here. Actually, you got to exhaust the possibility that you could bring him here. And if you want me to rule on the admissibility of this thing, you got to try to bring him here. And by the way, we don't have to do it in front of a jury, but you have to issue him a subpoena. And again, he didn't say you have to do it. He's basically like, if you want me to rule that this document is admissible, you got to bring him here. We'll talk to him outside the presence of the jury, and we'll find out whether he's available to testify. And so that's how they left it. And I would be shocked if the prosecution does not actually now drag Alan Weiselberg out of Rikers and have a 5-minute hearing at which he would assert the Fifth Amendment and make clear that he's not available. But that's just, my gut about what's going to happen at some point next week.
I think the judges suggested they could just zoom him in basically, and he had mentioned that he's done a number of trials or hearings in the past where they get someone, just a person in from who's incarcerated and remotely to do whatever testimony they needed to and clear it out. So I'll have to see the flesh, but we may miss that.
Yeah, and just to be clear, Justice Merchan is completely right that it is entirely normal, or even more common than not, that someone who is incarcerated in state will ultimately come into a state court trial to testify. It's really not something that is, to say that he can't testify because he's in prison, which is kind of what Emil Bovey suggested, and then also the prosecutors a little bit implied as well. It just doesn't track with the reality of what happens in state courts every day. And so there's a lot more going on here to unpack, because I just think that Weiselberg is a very complicated witness for both the prosecution and the defense. And at the end of the day, neither of them want to call him, but also both of them are dealing with the fact that they need to be thinking about how the jury is going to view that.
Right.
So I'd like to flash back a little bit, or flash forward if you prefer, but to talk about some bigger issues, because we're almost done with the people's case, it seems. And you've all had a chance to sleep on Stormy Daniels' testimony. What you've heard the direct, you heard the cross. How do you put it all together? Ben, what did you think?
All right, so let me first say that I was really, as people know, I was quite worried about the decision to put her on. I thought it was a bad cost benefit ratio for the prosecution. That is, she can't testify to any of the elements of the offense, and she can get shredded on cross-examination. And so if I had been in the prosecution's shoes, I would not have put her on the stand. They made a different call, the first day of which I think paid off badly for them. I think she was in kind of rough shape by the time she left Tuesday. But boy, was it a different picture yesterday. And she seemed like an entirely different witness. I think she embarrassed Susan Necklace, who is a very fine trial lawyer. But I don't know what happened between Tuesday and Thursday, but Stormy Daniels came back and she was, we had talked about how she had this kind of hurried speech and she seemed, quite nervous and she came back with her boxing gloves on and she was really combative, and she gave very little ground. I thought she was incredibly impressive. And so to the extent that I sort of feared a disaster for the prosecution, that disaster certainly did not materialize. And I thought she was an extremely impressive witness. What she gives the prosecution, however, still a bit of an open question in my mind. There's some sense of the motive for Trump to have engaged in this deal in the first place. But at the end of the day, the prosecution doesn't rest on the question of whether Stormy Daniels' story was true. And it doesn't rest on the question of really whether Trump, whether we believe her or not. It rests on the question of whether you believe his motive was election interference and whether the documents were falsified, none of which questions she really addresses. And so I came away with very mixed feelings about it. On the one hand, the disaster that I feared really did not happen. And I thought she was an impressive witness who did a lot of good for her own, to vindicate her own struggles over the last 8 years with this man. And I actually felt a sort of emotional satisfaction on her behalf as a result of it. On the other hand, it really is very marginal to the case, and I'm not honestly sure how a jury is going to react to it, and therefore I'm left with kind of mixed feelings about the whole thing.
Not much time left, but I want to get Anna's views on that, and ideally Jacob's too.
Yeah, well, why don't I spoke about it at length on the dispatch yesterday. So
Okay.
I would say that I agree with Ben that I think that there were some risks at putting her on, but at the same time, as I said yesterday, I think that she ultimately told the core claim that she was making about her encounter with Trump ultimately seemed to me to be very credible. I also thought that in terms of the motive about election interference, I differ in terms of what Ben's opinion is, because I do think that the story that she told about the sexual encounter with Donald Trump very much connects to the narrative being told about the Access Hollywood story, that there was this frantic plan to cover up some of these stories about Trump's interactions with women after the Access Hollywood tape came out. And that tape in itself relates to the power dynamic between Trump and women that he's interacting with, in which he famously said, if you're a star, they let you do it. And then, of course, the story that Stormy Daniels told was about a power imbalance between herself and Trump. And so I think that maybe goes to why it was that there's a motive or an intent to buy this story and violate the law potentially in order to do that. At the same time, the connection that was missing is the question of whether Trump or any of the people who were involved in buying the story actually knew what the details that she was telling about the story involved that kind of dynamic. So I think maybe that's the issue that the prosecution didn't quite link up, is what is it that Trump and Cohen or others knew about the story that Stormy Daniels was selling, even if they deny that it's true?
Okay. Jacob, quick, can you address it quickly? We're at 3:30 already, but.
Well, I think there's two like fraught moments at the heart of the story of this trial. One is, when the election was coming to a close, the Access Hollywood tape came out, and Trump wanted to keep the story quiet, which we've heard a good amount about, but we aren't quite in Trump's head yet with the testimony that we've heard so far. Maybe Cohen will give us that. And the other is a Stormy Daniels encounter. It's the one where the jury is going to be like, oh yeah, I totally see why he had to keep her quiet about that. And I kind of agree with the defense, with Trump's lawyers, when they say that the prosecution meant to have her like kind of make him out to seem like a creep, which he does come across in testimony. It's a bit of a low blow, perhaps, but like it's true in the sense that she did really do that. And the jury's left with that impression. The jury's left that this is a very unpleasant story, that it makes sense why, as the election is coming to a close, after the Access Hollywood tape, he wouldn't want the American people to know that. And I think that she really succeeded in bringing that out.
Okay. And just one question I want to ask before we close. Do you know who's going to do the cross of Michael Cohen?
I would be shocked if it were not Emil Bovee. He's leagues better than the other two at crosses.
Yeah, Todd Blanche's gift is not cross-examination. He has many gifts as an advocate, but it is not cross-examination. And Emil Bovee is quite lethal when he is on cross-examination.
And Susan Nichols, whom I have heard nothing but good things about, did a terrible job with the cross-examination of Stormy Daniels, down to some of the points that Anna was making yesterday about the very offensive, why did you wear, address that short kind of questions. What did you expect when you're a porn star? How could you be offended by a guy in his underwear, right? I mean, there was like, it was a very tone deaf cross that was handled not very deftly. And Stormy Daniels made a fool of her, I think.
Well, we will leave it there. Anna Bauer, Benjamin Wittes, and special guest Jacob Shamsian from Insider. Thank you all for joining us today. And thank you all for watching. If you want to support Lawfare's coverage of the Trump trials and watch this dispatch without ads next time, become a Lawfare material supporter at lawfaremedia.org/support.